Good evening. My name is Akila Mance, and it is my pleasure to welcome our audience here this evening to our panel, The Legal Battle Over the Desegregating of Rice. This event today is hosted by the Rice Task Force on Slavery, Segregation, and Racial Injustice. For those of you who have not had the opportunity to visit the task force website, I encourage you to do that. You will see all of the wonderful programming that we've had thus far, as well as links to resources, which include historical archives, webinars, doc talks with the chairs of our task force, and a lot of the information that's being discovered in the course of our process. One of the charges of our task force includes developing campus-wide programming to support frank and honest discussion of Rice's entanglements with slavery, segregation, and racial injustice. I will serve as your moderator today. I am a Rice alum as well as an attorney here in Houston, and I am happy to serve as a member of the steering committee for the task force. One final reminder to our audience this evening, you may submit questions through the Q&A box. We'll check that periodically. However, we will not be interacting on the chat function. So just submit your questions there and we will do our best to get to them. Without further delay, let me introduce our panelists. Our first panelist is Dr. Stephen Wilson. Stephen Wilson is an assistant provost for academic affairs and the university registrar at Lehigh University in Pennsylvania. Dr. Wilson earned his master's and his PhD in history at Rice University, where he studied US legal and constitutional history. He also has served as the vice president for academic affairs at Tarrant County College's South Campus. Previously, Dr. Wilson served as the first dean of academic assessment at Tulsa Community College and the associate dean of liberal arts at Tulsa Community College's Metro Campus. He began his career as a professor teaching American legal history and is the author of The Rise of Judicial Management in the U.S. District Court, Southern District of Texas, 1955 to 2000. He also received his electrical engineering degree from Rice in 1986 and practiced in that area until he decided to pursue higher education. Our second panelist is Dr. Megan Francis. She is an associate professor of political science and an associate professor of law, societies, and justice at the University of Washington. She also served as a senior democracy fellow at the Ash Center for Democratic Governance at the Harvard Kennedy School. Dr. Francis specializes in the study of American politics with broad interest in criminal punishment, Black political activism, philanthropy, and post-Civil War South. She is the author of the award-winning book, Civil Rights in the Making of the Modern American State. In addition to her research and commentary, she's been featured in numerous academic and public outlets, including a very popular TED Talk. Last but not least, we do have Dr. Michael Olivas. He is the William B. Bates Distinguished Chair in Law Emeritus at the University of Houston Law Center and Director of the Institute for Higher Education Law and Governance at U of H. He received his BA from Pontifical College Josephium and his master's and PhD from Ohio State University, as well as his JD from Georgetown University. He also chaired the UH Graduate Program in Higher Education and twice served as the Associate Dean of the Law Center. He is the author or co-author of 16 books, including the law and higher education cases and materials on colleges and court, 4th edition. He was chosen for the Esther Farfel Award, the university's highest faculty honor. He received both the Mexican American Legal Defense and Educational Fund, as well as the Hispanic Bar Association of Houston's Award for Lifetime Achievement. He is recently retired to his hometown in Santa Fe, New Mexico, with his lovely wife. Now, turning to our panel discussion for the evening. This evening, our panelists will explore the legal and historical details of the lawsuit, as well as the broader movement to desegregate colleges. As most of us know, William Marsh Rice grew up in an era where slavery was legal in this country. And by the time he began contemplating a university, the Emancipation Proclamation was announced and the 13th Amendment ratified. In 1891, Rice Institute was founded for white inhabitants of the city of Houston and state of Texas. We know that Black codes and Jim Crow laws legally reinforced institutional racism and segregation at the time, particularly in the South. When Rice's first class enrolled in 1912, segregation was indeed a way of life. However, over the next 5 decades, that way of life would be challenged. As early as 1948, Rice students began discussing and even advocating for desegregation. The university administration was unmoved, and the basis for their lack of action at the time was actually the Rice Charter. This conversation would continue, and it brings us to the early 1960s, which is where our conversation will begin tonight. A few of those key central figures are going to include President Pitzer, who was at the university, as well as the attorneys representing the university, and last but not least, Dr. Raymond Johnson, Rice's first Black student to attend, who actually started classes under the understanding that he would in fact be admitted. However, when the alumni intervened in the university's lawsuit, he had to put his educational career on pause, become a research assistant, and wait for that decision. So it's in this context that we approach the conversation today, and I am going to turn it over to our first panelist here, Dr. Wilson. Dr. Wilson, can you start us off with a few remarks about what context this lawsuit occurred in? And more specifically, I know that we hear, Rice initiated the lawsuit, and it sounds like we proactively and voluntarily decided to do the right thing and desegregate our campus. Can you tell us if that is the most accurate way to describe the factors that led to Rice's desegregation and initiating the lawsuit?
Again, thank you for having me. It's wonderful to visit Rice, even virtually like this, and to be part of such a distinguished panel. Answer your question, I would say, the first thing we should remember is that no, this was not an issue of the Rice trustees doing the right thing. If we look back on sort of the moral issue, or even the social issues of the civil rights movement, this was not Rice coming to the forefront. We were actually a little bit late in coming to the side of desegregation as a positive movement. That's not to say that there weren't other good reasons for doing what we now regard as, quote unquote, as you said, the right thing. And so I'd like to actually just have a couple of minutes to talk about some of the context of some of the things that were going on at the time. First, one of the things that we have to remember is that the legal case that we're talking about tonight that led to this change in the charter that had been in place, as you said, for 60, 70 years, was that it wasn't what we would now regard as a civil rights case at all. It didn't have the hallmark of plaintiffs seeking entrance to Rice. It didn't have the sort of arguments that we would see in other civil rights cases I'm sure we'll be talking about a little bit tonight. So there was no reference to the 14th Amendment. There was no reference to any of those sort of things. Instead, it was what was intended to be a straight nuts and bolts sort of legal issue, lawyers and judges working this out. And the legal questions I'm going to leave to my friend Dr. Olivas. But let's talk a little bit about some of the points that give you an idea of why this was going on around this time. First, let's go back, and I want to talk a little bit about one of the people that you mentioned, and that's Kenneth Pitzer, who was the president of Rice at the time of this suit. He became Rice's third president in 1961, and he was hired by the trustees to transform Rice into a major player in the higher education world in the United States and the world. Rice was at that point about 50 years old, if you count it from the first class, and they were looking forward to the next half century of growth. It was an exciting and dangerous time to be in higher ed. It was, this time was just after Sputnik had launched from the Soviet Union, and so the space race was on. The Cold War was on, and in the midst of that, we also know the changes that were coming around from civil rights. So you have all of those sort of issues going on. But there were other specific changes going on at Rice, both before Pitzer arrived and just after, and he had a part in some of those things. So let me talk a little bit about some of those. One major change just before he arrived was that Rice became Rice University. Prior to 1960, it was, as you know, from all the materials you've got there on campus, it was the William Marsh Rice Institute for the Advancement of Science, of Letters, Science, and Art. Why was that change made? Well, it actually is more important to this case than you might think. Long before the idea of desegregation had come into the issue, the trustees were looking at Rice's stature and its reputation and its potential. And they felt that the term institute was too limiting. They thought that becoming a full-blown university with larger graduate programs and all that is implied by that name was important. This was not something that was new. Rice's first president, Edward Olivas, had also thought when he was there for a few years that institute was too limiting, but they just didn't get around to doing anything about it. Now, this took a change in the trustees' rules, but it was something that they didn't really need to worry about the charter, because the charter gave them the authority to name the place by such a name as their judgment select. So they could just do it on their own. However, and this is significant, they knew it would be controversial, so the trustees did run it by alumni groups. They had stories in the Thresher. There were talks about this. There were alumni who emerged who were in opposition to it. They wanted the institute to remain the name. Others said, great idea, this is wonderful. I'm sure there was a set who didn't read the Thresher, who didn't know it was happening also, because things never change. But that was an important thing, so this went on. Number two, an important change that Pitzer did have something to do with. As part of its reputation, as part of its prestige, as part of its opportunity and its aspirations, Pitzer wanted for the first time to institute a system of tenure at Rice. For 50 years, there was no tenure system. And there also wasn't a pension or retirement plans or sabbaticals, and they were rare and all these sort of things either. But introducing tenure, which we now regard as sort of a given, was seen as a step forward because it would allow Rice, with the academic freedom aspects of offering tenure, but also the possibility of withholding tenure, It would put a premium on research and the other elements that go together with service to the university, as well as excellence in teaching, and allow Rice to start attracting what they would regard as world-class scholars. So that didn't come around until the early 60s also. It was instituted, finally was instituted in January of 1963, which was a couple of, 2 years after President Pitzer started. So that was important around this time. Why was it part of Rice's efforts? Because around the same time, Rice was engaged in an attempt to increase its fundraising imprint. What does that have to do with some of these issues with this lawsuit? Well, Rice was regarded, rightly or wrongly, as a wealthy school. One of the things that led to that sense was it was pretty wealthy. However, the endowment that it had, although it had grown over the years, was not large enough to do some of the things that Pitzer wanted to do, which was increase enrollment, add graduate programs, and as I said, engage in some recruitment on a large scale for faculty. Because to do that at this time, in the context of the space race, in the context of the Cold War, in the context of all that, meant building buildings, building laboratories, and attracting scholars in a very large way. Rice wouldn't be able to do that without also raising a lot of money. And so there was decisions made at the board level to set goals to fundraise were actually pretty ambitious. It did lead to actually about the raising of what ended up being $43 million throughout the decade, which is today something like $250 million. So it was pretty big. Next point, back to the space race. Rice needed to make some changes along all the things I've just mentioned in order to have its good relationship with NASA. NASA, very important in Rice's history and the myth of everything. JFK gave his "We will go to the moon in this decade" speech at Rice Stadium in 1962. All of these things are very important. But one of the things that Rice had to do in order to do that was the fundraising, was the faculty improvement, was the higher prestige. One of the things that would also lead to, my next point, I'll come back to some of these, they needed more money, not just in endowment, but they needed operating funds that they could use generally around the campus. And so they wanted to institute tuition for the first time in Rice's history. One of the reasons that people thought that Rice was so wealthy is because they could afford to allow people to come without paying tuition. That was sort of true, but it was also becoming clear to Pitzer that this was no longer sustainable for some of the goals that he and the trustees wanted to see throughout the 60s. And this wasn't a new issue. In fact, in the 1920s, the trustees had already started to say that we're running out of some operating money, there's a pinch, let's institute some tuition, let's extend some fees, all of these sort of things. I'm not going to go into some of the numbers because they would make current students and alumni cry, but they're on the order of like an $18 per year fee. Unfortunately, the Depression and then World War II intervened and things like that, and so this was put off. But by the 1960s, this really needed to happen. And my final point of some of this context is the civil rights issue. Back around to that. And it was that fundraising, grants that Rice needed to apply for through the federal government and also through private foundations were increasingly going to be restricted to institutions that had desegregated, institutions that were more open, that elements of all of the prestige and the tenure and endowment and all these things would not be enough to convince the government, Ford Foundation, other foundations to put their money into Rice to lead to the reach of its aspirations. And so these things came together, the money and the civil rights issue the tuition, which were both parts of the suit, the tuition issue and the segregation, both had to come together. And that's what led finally in the early 60s, in 1962, for the trustees to finally decide that they were going to try to change the charter specifically so that they could do these two things. And it should have been a relatively simple thing. There were some on the board that thought that they ought to run it by the alumni the way that they had done it with the name change. Instead, they ran it by the lawyers. It seemed like it was going to be a perfectly easy thing because in this case, it's the judges and the lawyers. But soon after they filed the papers, effectively asking the Attorney General of the state to allow them to change the charter, they were hit with the complicating factors of alumni groups hiring their own lawyers and then intervening into the case. Very unusual. It led to a lot of strange legal arguments back and forth. Ultimately, we know that it turned out that the trustees won the case, but it did delay things. It took a number of years to go through appeals and things like that. And I'll leave some of those legal arguments to the others on the panel. That's some of the context of what's going on there. So just to summarize, there's a number of things that are going on that led almost in a straight line to this crazy line that then started to go off the rails a little bit with the lawsuit. So I'll leave it at that and come back for some questions if we have time.
Thank you, Dr. Wilson. Dr. Olivas, we've heard from Dr. Wilson about many of these factors leading up to the lawsuit, but this case wasn't like most lawsuits challenging segregated colleges in America, as we referred to earlier. What about this lawsuit made it so unique?
One of the most interesting things about this is how a very carefully articulated and planned and strategic case, which was just supposed to be saluted by everybody, turned out to be as vexed as it was, not only taking longer time and making it more expensive. This also, of course, added to the legal costs. But it's so interesting and so unique that I actually include this particular case as the very first case in my higher education law case book. And because it does not only get at the question of what is a college, but what are the kind of legal contours that determine colleges and universities' governance. And it had gotten along quite well for a long time. And there were, of course, schools like MIT and IIT in Illinois and some other places that still remain institutes, but they had a narrative that they were fully engaged in. And it was a narrative that could have been very ugly in the sense that it was established for the free white inhabitants of Houston. But over the years, although they didn't admit any African-American students, except for this one exceptional student who was sort of waiting in the wings to have permission to go there, you can imagine how stressful that must have been and how extraordinary he was. But they'd also had over the years some honorary whites. There were a few Latin Americans who were there who were not not very political about it the way it would have been the case today. There were some international students, including students from Japan and China, who were there, who were sort of deemed to be honorary whites. And in a world, as in Texas, that was very bimodal. There had been a 1951 case, a case the year I was born, called Hernandez versus Texas, where a Mexican-American was engaged in a bar fight and he shot another Mexican-American. And the question was whether or not his being tried by an all-white jury in a town near Victoria, Texas, that was 15% Mexican-American, whether or not that was a jury of his peers. And it turned out that the court said, well, in Texas, you're either white or you're black, notwithstanding these honorary Chinese or these honorary folks at Rice who did not enter the record. I'm quite familiar with the record, and they didn't really look at colleges. but they had lived like this. And in fact, that particular case goes all the way to the US Supreme Court in 1954. It's the case before the Brown decision, and it gets lost in the light of Brown because it came just beforehand. But the question was whether or not Mexican Americans were white, or whether or not the segregation in this small town and their complete exclusion from both political and social and economic life in rural Texas meant that he had been tried by jury of his peers. And the Supreme Court, interestingly, overturns the trial result where he was found guilty. He had done it in front of 50 witnesses, and he was retried with a jury that had 2 Mexican American women. Now, women also didn't serve on juries at the time, but the point is that there had been segregated bathrooms in the courthouse, and Justice Warren, in one of his first major cases as the Chief Justice, picked this particular case because it was a criminal companion to Brown. So part of the background was the extent to which non-white groups were to be considered as whites or non-white groups in the state of Texas. Now, there had also been an important case in 1950 that included whether or not the University of Texas Law School could have a manufactured evening program in a basement and call it a Black law school, or whether or not they would have to admit Heman Sweat into the university. And again, in a unanimous decision, they overturned that, saying that it was separate, but it wasn't equal. And so there had been all these externalities that were going on that affected this. And I don't think these guys ever thought they would stumble into those narratives, because this wasn't about race in and of itself. I truly believe it was about their moving up in the world, which necessitated more money and indirect costs and relationships, not only with NASA, but with NIH and NSF and all the other kinds of increased research that was available, which would also fund graduate students. So it would pay for their tuition, not just charge them tuition. But the charging as tuition became the key figure here. And I don't think that they expected alumni to complain about this, because they technically had no standing. It's always been of interest to me in reviewing this particular record that there was no real argument about whether or not these alumni could actually go to court. I mean, after all, Coffey is the alum, and he becomes in this case, Coffey versus Rice University that we're talking about, the 1966 case, he becomes the plaintiff, and he ends up losing. And so they spin off 2 real issues. The real question then became whether or not it was actually feasible to continue to operate not only with only white students on the books, especially with a Black student waiting in the wings and a narrative that we wanted to be more inclusive, which they had, as I say, observed in the breach, but not very often. It was still overwhelmingly a white school, both in the faculty and in the student body. But there is a legal doctrine, a legal technique called Cy-Pray that allows a trust instrument to be reformulated, or to allow a deviation from that if it were no longer feasible. And my book includes a dozen such cases. One at Ohio State University, where they had some scholarships available for certain students who were the children of employees of a certain railroad. The railroad had died years before, and there were no such children anymore. So they reformulated that, they redid that. And there were a bunch of public parks that were also money given by families that said no, only whites were allowed. It became impossible, in part because there were often in parts of town where there ended up being no whites residing nearby. So for a variety of reasons, it was simply infeasible. And a jury trial held that they could reformulate it, and they sort of sidled off into the tuition, which had some ambiguities about it. There was no ambiguity about the race, but there were some things about whether or not anyone could, just as one example, whether or not the enjoyments would be free and open to all. the will wasn't, the trust wasn't written in a particularly tight way. It had these ambiguities, and it had, they could have written it so that the trustees could have changed it without having to get a court opinion to ratify it. Of course, they also had to line this up with the state's attorney general, who would have had to interpret this as well. So in the legal sense, the doctrine of cypre allowed them to reconstitute the trust and not only allow tuition to be charged, but to change the admission restrictions as well, and to make it a freestanding university, but with having been reconstituted. And I might add that a lot of institutions were going through the same kind of growth, and particularly private institutions. There's some reference in here to publics. When I started teaching at the University of Houston in 1982, tuition was $4 an hour. Out-of-state tuition for public institutions or international was 10x, whatever, so it was $40. The next year, they changed it to $12, and there was blood in the streets. People were saying, oh, they've tripled our tuition. It was $4 an hour. Now, that's no longer the case, of course, because these institutions were leaving money on the table. That would be the final point I would make, that while this is guised as a legal issue, it genuinely, there was substantial money available, especially for science research. And as a result, all Texas institutions began to upgrade their science capacity, especially in the graduate programs, and to begin to have patents and to begin to hire more scientists and to have science research going on. They would not have had access to that money. And believe me, there were many schools outside of Texas who would have. So in order to be competitive, they really had to do this. Had this gone the other way, and ultimately they'd been stopped from doing so, I think that it would have, that Rice would have been one of the great could have beens instead of the great school that it is now. I'll end there. I'll be glad to answer questions if people have them following our discussion.
Hi, good evening, everyone from Seattle. My name is Megan Francis. I am a 2003 graduate of Rice University, Baker College. I first just really want to express my gratitude to Akila Mance, who's gathered us all here together, as well as my other two panelists. I'm already just learning so much, especially sticking out to me is the price tag previously. So thank you so much for that, Professor Wilson. Also, my deep gratitude to the Rice University Task Force on Slavery, Segregation, and Racial Injustice. I am so glad that you guys have formed. It is overdue. I am grateful, deeply grateful. We all are to your service. All right, so I'm going to speak a little bit about just to provide a few minutes in terms of context around what is actually going on in terms of the broader context. My specialty is not so much kind of what actually happened with the case. I'm learning that from my fellow panelists, but I do really want to make clear that to understand how institutions change means to understand kind of the environment around them and the kind of the pressures that get placed on institutions to, I guess what the kids say these days is to act right. So what is going on and kind of in the environment leading up to this Rice decision in 1962 and to the later battle is again that the world is changing. That in terms of, for example, if we focus specifically on institutions in terms of higher education and the battle around race and higher education, that in terms of the Ivy League, all Ivies except Princeton had admitted Black students before World War II. Princeton did finally did so in the mid-1940s. Princeton was always kind of the Ivy of the South. However, what is really going to be transformative to think about the desegregation in higher ed is going to be the NAACP's campaign around segregated education, which began in 1931. And it was three-pronged, really. They focused on equalization of teacher salaries, equalization of the infrastructure of schools, as well as wanting to integrate not just like in terms of K through 12 schooling, but also higher ed and graduate and law schools as well. So there's two cases so they begin in 1931. And they litigate a number of cases that then lead up to two big cases in 1950. The Mclaren v. Oklahoma State Regents case, as well as Sweat v. Painter. The Mclaren v. Oklahoma State Regents case was a United States Supreme Court case in which the court ruled that a public institution of higher learning could not provide different treatment to a student solely because of her or his race, as doing so deprived the student of his or her 14th Amendment rights of equal protection. The unanimous decision was delivered on the same day as Sweat v. Painter. These cases began to question the separate but equal doctrine as it applied to higher education. And in so many ways, Mclaren and Sweat laid the groundwork, even though they were kind of higher ed cases, still this idea around education and what is the court's promise and what is the Constitution's promise. They laid the groundwork for the court's ultimate big decision that I bet that everyone on this call knows, which is the 1954 Brown v. Board of Education Supreme Court decision. And in, of course, this landmark decision, the Supreme Court held that segregation in public education violated the equal protection clause of the 14th Amendment, right? So we know that after Brown v. Board, at least Jim Crow's not anymore, but Jim Crow, at least in the area of education, the court says it's unconstitutional. So it's in this legal context that provided an opening that something else was possible for those foot soldiers and people on the ground who wanted something different, as well as people who are already attending schools in the North, as well as schools in the South. The Brown decision inspired student marches across the country and especially in the South. Black and white students took to lunch counters across the South, but they also advocated inside and outside the hedges. Segregated institutions of all stripes needed to fall, right? And there was, in part of the reason why I'm kind of focusing on that aspect around students, and I know we're going to spend more time in this conversation talking about students, is I think oftentimes we talk about the dramatic changes that happen in American society from the 1950s and the 1960s, and we tend to place a lot of emphasis on leaders as well as politicians, as well as legal actors. And yes, all these things are important that led to a dramatic sea change in the way that this country understood itself, as well as its promise to Black people in this country. But it's also really important to understand like the role of students in pushing these institutions to be better. All right, so elite private institutions in the South face growing calls. We know this, of course, for desegregation: Duke, Emory, Rice. Though unlike their peer public institutions, no federal court ordered these schools to admit Black students, and no troops arrived to protect access to the schools for Black students. The grassroots civil rights movement created a national crisis of conscience that led many individuals and institutions vital to colleges' survival to insist on desegregation. And it created for public institutions such as Rice University, at least for some, not all, but like, what is the responsibility and how much should we as a private institution that is not, at least right now, bound by these like federal government orders, how should we respond? How should we actually behave? Like in terms of the writing seems to be on the wall very clearly by 1962, even more so obviously after 1962, right? So right in 64 comes the Civil Rights Act, in 65 comes the Voting Rights Act. The world, this country is changing, not at the speed that Black people want it to, not at the speed that it should, but it's changing. So for example, pressure came from the following entities: the press, the media, of course, accrediting bodies, professional associations, alumni, professors, right? Professors, I see some professors on this call, hey there, right? Professors inside of these institutions wanted these institutions to behave better, and Northern foundations, what Professor Wilson spoke about, and individual philanthropists, and this is gonna be key. I focus right now some of my research, not specifically on the relationship between philanthropy and higher ed, but on the role of foundations in terms of social justice and in the development of political and legal institutions. So tensions were being strained. All this pressure was coming from students, from the outside, from funders. So in other words, people on the outside, in so many ways, increase the cost of being racist, increase the cost of having a segregated institution. And that's part of kind of the environment in which that provided impetus for Rice to actually change. So I'll stop there. I'm really looking forward to answering some more questions from Akila as well as the Q&A later.
Thank you all for giving us those sort of highlights about our discussion here today. I think there's so many different places we can go, and I know that each of you had a few points that you raised that you wanted to come back to. I can say, just sort of listening to the first part of the conversation, I haven't heard a lot of arguments from Rice at that time to desegregate just because it was the right thing to do, right? As Dr. Francis mentioned earlier, Rice is late to the game, okay? We have decisions already, at least dating back to the 50s, that are fleshing out these conversations, moving the nation towards desegregating. Perhaps Dr. Wilson or even Dr. Olivas, in your research that you've done about the case in Rice, do we see any arguments about why desegregation is either the right thing to do or just makes sense to do at the time of this lawsuit?
Well, I'll go in alphabetical order then. Just very briefly to say that the city of Houston, of course, was also transforming itself. They had made the port an important feature. The medical school right across the street from Rice, of course, had grown into the world's largest. And the city itself was growing, and part of that was NASA, which has already been mentioned. But the interesting thing was, at the time in 1962, during the pendency, the first stages of this case, the University of Houston was a private institution that had just gotten state law to change it into a public institution, which meant it would have to desegregate in order to do so. So it admitted its first Black students in 1962 who took courses but didn't yet get degrees until after 1963, when it kicked in and they became public. That's why the University of Houston today is 45,000 students, because it's public. At the time, the only public institution in the city was Texas Southern University, an historically Black institution that had been featured in the Swat v. Painter case, even though the institution had moved to Houston, including the law school. They began to turn the YMCA institution at 1 Main Street into the University of Houston downtown. And then all the institutions began to grow, and the community college system began to grow. But in 1962, Rice was about the same size, just a little bit smaller than the University of Houston, which of course had a pharmacy school and a law school and some of the other graduate programs that made it larger than Rice and gave it the base to become the large growing public institution it is today. But that's the part, Professor Francis, that I thought I was hoping that you would point that out, because it is so crucial to this timing, and it was in the air when it became a private institution. And some of its people also didn't, some of its alums also didn't want to change. And it had been predominantly white, although there'd been some Mexican-American students early on. Again, this bimodal, if you're white, that Mexican-American makes you white. So the context is not only the peer schools like Duke and the others, or the Ivies, and it's not even the other institutes in science. In Houston, you had to live within an ecosystem as well that was also changing. And there was a desegregation case that was thriving in the Houston Independent School District, which is one of the 18 school districts in Harris County. So it was both K-12 pressure, because that's the feeder schools, at least to the other institutions, not so much Rice, and the legal changes that occurred there that exacted more of the public institutions. It also, of course, began to eclipse Texas Southern, which at the time was the largest of the institutions because it was the only public one. And it and Prairie View sort of had divvied up the public HBCU world for the state of Texas.
And I'll agree with all of that and second it, and just a couple of points to add. First, thank you for the shout out for Prairie View. That was my first institution after getting my doctorate, where I taught there for a number of years before heading to Tulsa. I would just add this, that I don't think that that at least in the trustees, there's a lot of evidence that there was an argument that the moral issue was more important than the financial issue. There might have been, but I haven't seen it in the records precisely. But what we do have is what you've already shown us, which was some of the student activism, or at least some of the student opinion that was already current at the time in the late 50s. But it actually goes back much earlier to the late 40s, around the time of the Sweat case. Because remember that was going on across town. The Texas Southern, or as it was then, Texas Southern University for Negroes, TSUN, was actually one of the institutions involved in some of that case, some of the decisions in that case. And because of that, it was a live issue that's just crossed down from Rice. And at the time, the president, I want to make sure I get this right, it's Professor Houston, or President Houston, was spelled Houston, was also asked by students, why aren't we following along with this? This was in the late 40s. It was after the desegregation of the military by President Truman, for example. It was as these significant cases were working their way through the system, there was sort of a change going on. And so there were students, or at least the current editorial board of the Thresher, that was making the argument that Rice should be at the forefront of this. Houston is going to be a great city if we do this. There's all, Rice will be a great place if we do this. All those sort of arguments of why it was the right thing, and it was in good interest for Rice, but also just the right thing to do. And at that point, Houston would just point to the charter and say, maybe so, but the charter won't let us. And there wasn't really any effort or interest at that time to do anything about it. There was no challenge that came to it. So although there was some student opinion, I'm sure there was some against as well as for, that's about where it was for about a decade. You didn't have any students that came to sue. You didn't have alumni that came to sue to change it. You didn't have those sort of things. But part of it was also, as I said before, part of it is that the infrastructure of how those things happened just didn't seem to be in Rice's system yet. They didn't have the fundraising capacity that you could challenge. They were living off their endowment, so there wasn't a lot of that. There weren't students who said, well, we just won't bring our tuition money, because there was no tuition money. So there wasn't a lot of levers other than naming and shaming. And ultimately, avoiding naming and shaming is what led Rice to finally decide to take these steps. Because although it was financial, they were worried that the finances were going to be challenged because of being called out by the government, by the foundations, and ultimately by the public as well. So a little more context to that.
Before I shift gears and perhaps ask Dr. Olivas to give us a little more about the procedural posture and sort of the arguments that were made in court, I did want to perhaps kick it back to Dr. Francis, maybe pick up on a little bit of what Dr. Olivas said about, other movements that were influencing the moment. We know that life inside the hedges can be a little bit insulated at times. And you talked about the importance of movements happening around Rice, as well as even student movements. And I wondered if you could speak to a little bit about the role of how those sorts of movements and advocacy could influence Rice's decision back then. And let me also because I did not mention in my introduction that you are also a Rice grad, and that you received your master's and PhD in politics from Princeton University. So let me make sure to put your academic history out there as well, as I've done for the other panelists. So let me turn it over to you for any thoughts there.
Okay. So I just, in terms of a quick clarification, Akila, is this a question about in terms of Black students at universities such as Rice University, especially if we focus in on Rice University in terms of the organizing that they do to hold these institutions accountable, or about the experience of Black students when they are at these types of institutions?
The former, so the first.
Yeah. Yeah. So, I mean, my experience and at least my expertise is not necessarily with how different groups were organizing during that time, but my experience and what I can speak to, and I would be really happy to speak to this, which is my experience as a Black student at Rice and what that was organizing around these issues. I think that at least my understanding in terms of being a student, as well as knowing a bit of the history of the desegregation of Rice and other schools in the South and outside of the schools, outside of the South, is that many white officials believe that they have seemingly done enough to ensure equality by allowing Black students to attend. And for many young people who grew up through the civil rights and Black Power movements, and or grew up kind of in the generation afterwards that heard the stories from their parents, from their grandparents, did not believe that admission to these institutions obligated them to gratitude, and that merely being amongst white students at a place like Rice was not impressive. It's also clear, in terms of being a student at Rice, that these institutions, Rice I'm clearly talking about, was not designed for Black students or Black faculty in mind. And that, I'm just thinking about some of the events during O Week, as well as events throughout my 4 years at Rice University, that oftentimes it didn't feel like we were welcomed. It more oftentimes felt like we were enduring, whether it was issues around housing, different types of campus events as well. And it is, I think, for me, in terms of when I first got to Rice, Akila knows this, when I first got to Rice, I wanted to leave Rice. I wanted out. I applied to UT. I applied to so many schools on the West Coast and on the East Coast. I was like, this place, oh no. like they brought me here and that was great. But it is, just in terms of the course offerings, at least in my opinion at that time, there wasn't a lot done to make Black students feel comfortable. And so later on, the reason why I actually stayed and why at the end of 4 years, and still I sing Rice's praises, I love Rice, but a huge part of the reason why I love Rice is because of the community that I met and the organizing that I did through the BSU, through Advance at the time, with other Black students and other students that were at the time in Hacer and in different organizations, in terms of trying to make space, creating community, and in different ways, pushing the institution to have a different set of talks, to operate differently so that we could actually be seen. It's always been the case, I think, and it's still, when I look at some of the stuff on the website now, it's always been the case to me that we make these institutions better. But I think in terms of love to have seen Rice as an institution coming out of the 60s, 70s, 80s, 90s, when I got there at the end of the 90s, do more to welcome Black students at a place like Rice University.
I think you raised some really interesting points of conversation there that I would love to pick up on a little bit later in our conversation with, as you stated, if Rice's primary motive here was, we need these federal dollars, we need the money to be able to continue to do all the wonderful things that we want to do that don't necessarily have to do with admitting students of color, then that does sort of lay the framework for perhaps an environment where students come in and there's not a focus on their inclusion, their success, and making sure that it is a welcoming place. But, I will give credit to Melissa Keene, who's done a lot of research in this area and talked a lot about it. And some of the documents and things that we've seen is that, Rice actually didn't really do a whole lot to support students, period, Black, white, or otherwise. It was very much a sink or swim. And there wasn't this notion or concept of inclusion and student support. It was foreign concept. So to have that sort of environment, plus, the admission of Black students as more so transactional, right, to get the money we need to do the other things we want to do, you can see how some of that foundation may or may not have been as intentionally supportive as one might like. But before we go down that road, I actually want to go back to Dr. Olivas. I think, obviously the title of our panel here is about the lawsuit. And so much about the nuance of the lawsuit is not really well understood. So I know that you've written about this, you talk about it, you teach it. Can you kind of walk us through some of the highlights of the procedural posture, as well as the legal arguments that were being made on both sides?
I will do so. I must say, though, although I went to college before the other two panelists, I remember trying, even at schools in my native New Mexico, where Mexican Americans are more than half the population, it was always my interest in integrating with a completely different group, but the same kind of narrative. You know, you've got one professor who's got to be everything to everybody, or as soon as they get a president or a board member, that person becomes your vessel of hope and optimism for the institution. And the same was true, by the way, when I was on the faculty at the University of Houston. For 16 years, I was the only full professor of Mexican American in the entire faculty, a faculty that's over 1,000 people now. Now that some of that has changed, of course, but each group that comes in, and you can imagine these poor international students who sometimes come into a school where they don't know the cultural norms of the country, much less of the institution. So I think that you're right, and I think that institutions have over time accepted the responsibility for having better student services to inculcate the variety of usually for retention purposes. I think they were afraid that they would just bring a whole bunch of students in, they drop out. It's a cycle. So I think that schools have become more woke in that particular sense, although it may also be for the wrong reason. The interesting thing about this particular case is just how ordinary it is. This could have been the construction of a will that left money to a family. It could have been, because people can do whatever they want with wills, as long as it's legal within the norms at the time. But what happens here is that the norms of our country, not only of higher education, but our country, overrun it. Very few institutions then or now had free tuition. Schools just couldn't afford it. Even the most wealthy schools can't do it today. And the pandemic, of course, has shown just how difficult that is, because schools are barely hanging on in many respects. It was unusual that alums got standing to do this, and I think it was because the kind of someone must have known the judge who prevailed upon him, and he said, "Well, as long as you're here, you might as well raise. I'll hear the objections." But he, of course, he goes back and he reinstates what the jury had already found. So here you have, it's not intervention by alums who want to do the right thing. These are alums who want to sabotage this entire thing. And it wasn't, my guess is, it wasn't their objection to the money and paying, not paying tuition anymore that was an issue. My guess is that there was, and I've talked with some family members of people who were involved in the case, and it was very clear to me that the narrative here was not a social justice narrative. And to its credit, Rice, at least in my experience, and all of you as alums have better access than I do, but I don't think they've ever held themselves out as a woke institution for this. This was instrumental in a very direct way to become a better institution. And I think they felt that it was awkward that it was for white inhabitants, and it would ultimately hurt them in their standing in the world, because having access to the best students in the world is what distinguishes Rice today. You guys get all these great students. I kept saying, if Rice really wanted to become a Mexican American institution, you got to have a board member who's Mexican American. They finally got one. They've made some changes. There's been some hiring and so forth. It's hardly a woke institution. Alberto Gonzalez is perhaps one of your most impressive, memorable, accomplished grads. But every group sort of goes through this. Now, it's true that the laws kept blacks out and African Americans out in a way that was more formalized, not only by law and by practice, but by case after case after case. And it's also true that Mclaren and which I didn't mention because it was an Oklahoma case instead of a Texas case, but Sweat v. Painter, both of which were the products of the NAACP, what is now the Legal Defense Fund, moving forward with this wonderful agenda over time, sort of seeing the dominoes fall. They had no hook over private institutions, but the private institutions began to compete with public institutions for money because a lot of money is given regionally. So if Rice University gets money from NSF for buckyballs, let's just say, there's no way the University of Houston's going to get it because they're both in the same congressional district. These things have to be spread around, and you start having these kinds of competitions. The competition was going to get more ferocious, and I think Rice properly realized through this case that they thought would be simple, and it almost fell apart. My guess is there were a lot of surprised lawyers when access was given to the alums who could have sabotaged this. This judge could have gone the other way. I think it would have been hard to do because they were clearly on the wrong side of history, and Rice could say the right words and have a narrative that seemed inclusive. Although, as everybody on this call, I think sees it for what it was. I guess I'm the only other thing I would add about this particular case is there's a whole series of these kinds of cases where institutions had money and they could no longer do that kind of thing. I cite Deep Springs, a small school that was all male, and the trustees tried to change it, and some alums who had graduated from there, then gone on to Cornell, had done the same thing that Coffey and the others did. They intervened, they slowed it down for 3 or 4 years. Finally, the court saw in their way because they had no true standing. Unless it's an alum who's a trustee or something like that, like James Baker, let's say, someone like that of his reputation. Well, then I guess they might have standing, but then there would be a trustee is not going to ever intervene in a case like this, and sabotage it. I think he or she would be removed from the board. So it happened to fall apart, but then miraculously it worked out in a way that moved it on. And I don't think most people today understand including African-American students. My guess is they don't all understand that they weren't welcome there before 1962, 63, when they started parking this guy ready to become a member. So I'm not sure the real value of this entire exercise is making all Rice students from that era aware of who went before. I always think that gets lost in the shuffle because we're just not narratives aren't organized that way. But that in my view is the most memorable part here, and having alums step forward and talk about it, I think is salutary for the institution. Even though they're doing it for these kind of what's the right word? Trying to clear their history. I don't know about statuary on campus, but a number of institutions have, Princeton, your alma mater, said we have a lot to do and we've made some mistakes and we admit racism. Brown did the same thing, and then some folks turned around and said, well, then you weren't in compliance with Title IX or Title VI. So sometimes when you put out the narrative and make it clear and own up to it, you can get mousetrapped. And I don't think that's going to happen here because it's a private institution. But some public institutions who might admit that they made error before and they now confess and own up to it and try and have some form of reparation, if only through scholarships or something like that. I don't think that's going to happen here, but it has happened to some schools that have gone back and looked at their earlier history.
And you definitely raise a lot of really good points there. Did I see you getting ready to interject there, Dr. Wilson?
Just a little bit. I wanted to add a couple of things to some of the nuances of the case, and that's that there was the one group of alumni led by Mr. Coffey, who ended up taking it onto appeal and et cetera. But there was also another group of alums who saw that intervention and decided to intervene in support of the board's action. Neither one, I think, really belonged in the case.
Right.
Michael has said it should have been straightforward, but having let one in into the discussion, the other side came in, and that's where I think that has been said. It kind of spun out of control, because at that point, all the board wanted was an okay by the Attorney General,
Right.
who was willing to give it. In fact, the Attorney General, Wagner Carr,
In advance.
ended up hardly saying a word, or his people hardly said a word, hardly responded. They were just sort of nodding along going, yeah, sounds great. Okay, fine. So there were no high-flown speeches from anybody who was the actual participants in this. And then suddenly you've got these other folks joining in. Now that is, I think, the one instance where this case starts to look like some of the other civil rights landmark cases that we're used to, and that you have interveners, you have friends of the court, you've got other people joining in, and and there's extra briefs, and that ends up being part of the richness of some of these cases. That's not what happened here. This is not part of the richness of the case. It's part of what has been said that slowed it down. Because what happened is they were arguing a completely irrelevant point, in my opinion. The trustees were seeking to amend the trust articles for the general fulfillment of what they took to be the actual aspiration of the founder, which was to be a university of the first class, or to be an institution of the first class. Name it whatever you want, do whatever you want with here, but it wants to be an institution of the first class for the people of Houston, Texas. And they thought that these two things were a barrier to that striving for being first class. The alums on either side start arguing about whether it was breaking the will of the founder, when it really wasn't about the will, it was about the actual trust documents. And as Michael has said, there's a way to do that, and there's the proper way to do that. And they were doing it the proper way. But instead, they turned it into a bit of a mess. It actually had a jury, so it went to a jury trial, which these things never happen in these sort of cases. These are cases usually held in equity, which means the judge and the lawyers figure it out. But they allowed a jury, they paneled the jury found for the trustees, and there it was, and everybody thought it was fine. But then the losing alums then appealed. And so that kept it alive. So they walked in and essentially took over the party by then appealing it and delaying final judgment. And that's one of the things I think that is sort of interesting about this as well. And then it goes back down. Ultimately goes to the Texas State Supreme Court, and is ultimately sent back down to say, look, take it back to the decision that the original jury had. But they, at the time, the Texas Supreme Court actually complains that the lower court of appeals had made some wrong decisions on this too. So now it ends up being a case about the procedures of the appeals court as well as in the trial. So shouldn't have gone on that long. It had lots of people involved who shouldn't have been. They were making arguments that really weren't the point. It sounds like a lot of faculty discussions, really.
Yeah, and I really like the way that you laid that out, Dr. Wilson, because, there definitely has been discussion about the lawsuit and how Rice desegregated in, various forums over the years. But I don't know how clear we really make it in regards to, how the lawsuit unfolded. And I am more than happy for you all to correct me along the way if I'm wrong. But it's in 1962 that we have that vote by the trustees, which, is a long time coming. And that's specifically why that particular president comes to the university. He does that on the condition that Rice will desegregate. Now he came from Cal Berkeley, so, maybe he also very much believed in desegregation, but also he had strong connections to the federal government and knew that there was no way Rice was going to be able to do what they wanted to do if they didn't get the federal dollars. And the federal dollars were not going to come so long as they were still segregated. And even more so, clearly and plainly segregated based on the charter. And so that vote happens in 1962. Well, let me back up. That happens in 1962. They consult with lawyers and do all the finagling they need to do so that they actually file that lawsuit early in 1963. Under that understanding, Dr. Raymond Johnson, the very first Black student to attend and graduate from Rice, he's here. You know, he's come to Rice, to campus, understanding and believing that he's going to be a student. And as he's beginning his coursework in that fall, he gets notice from the university, pause, you know, we worked this out with the Attorney General. We worked this out with the Secretary of State. You know, we've finagled all the votes we needed to. We thought this was going to be easy breezy, a stamp. Just kidding. Now we have a full-fledged lawsuit. And when the alumni intervened, his career was put on hold at that moment, where he entered into that sort of, you know, fake, I guess you could say, categorizing of him as a research assistant. And so throughout that entire year, they're litigating. Like you said, it is 1964 when that unanimous jury verdict comes down on the side of the university. And although they continue to appeal all the way up to the Supreme Court and through 1967, the university takes that first jury verdict and runs with it. And so Dr. Johnson is allowed to come in immediately that next school year and begin his tenure at the university, even though the litigation technically is still ongoing. And I think we've always had a lot of confusion about those years and dates and who was the first and when. And there's a reason why it's messy and gray. It's because the entire situation ended up being a little messy and gray.
But as I indicated, the same thing happened at the University of Houston. When they became public, they enrolled several Black students in the School of Education, and they were parked in the same way, but they did it a year before it actually kicked in. The law was passed in 62 to begin in the year 63. So they had the same kind of interim. These guys were in limbo. They went there on a promise and a prayer. And at the same time, the university was integrating its athletics. No one has mentioned here the role of athletics and how race. I'm confident that there were discussions, although I've never seen board minutes, that if these guys wanted to play in the Southwest Conference, which they did, to play big time Division I football, they would have to desegregate, not because it was woke, but because they had to have those players come. And the University of Houston was the first school in the Southwest Conference to have Black players and football players, and they became extremely successful. And if Rice was going to play with this big stadium, 90,000, where it's big enough they could have a Super Bowl there, as they did one year. My wife was in the high school audience there when President Kennedy made those remarks that you mentioned, Stephen. So they were ready as well, but there's no way they could have not included Black students because of athletics. And so I that's, no one mentioned that. I was sort of, because I don't know the timing of when you entered Division I at a big time level. But that seems to me worth examining, maybe with an historian or a dissertation or something.
Well, Kennedy did ask about why Rice played UT in that speech. So,
yeah.
Dr. Francis, I'm going to give you an opportunity to hop in here. I have a question, but I will defer to you first if you wanted to add anything specifically to the conversation thus far. No, okay. So, Dr. Olivas did mention about the NAACP and its efforts during that time and even prior to, and I know that's one of your areas of specialty, you've written about it. Can you talk to us a little bit more about what the NAACP was doing at this time in similar litigation?
Yeah, I'm happy to. So what the NAACP is doing now, I mean, what's interesting in terms of their whole trajectory, but it really is centered around, I mean, if we can move just a tiny bit outside of like the walls of the academy here, but really centered on kind of a broader struggle about how do we achieve and fight for rights for Black people in the United States. And so before they start before they start to focus on the desegregation education battle, the focus is really on racial violence and like focused on the increases in lynching and mob violence that happened all across the country, not just in the South, but all across the country in the first and the second decade of the 20th century. They then move like in the early 1930s to a focus on desegregating education. And they really, in terms of in so many ways, part of the reason why today we think of, at least even when I pull my students, we think about kind of the promise of civil rights. It is in so many ways rooted in education, right? This idea that like at the very basis that every student should have a right to go to schools and to be educated in this country. But that really comes through what is going to be a fight through the 30s, 40s, 50s and 60s, and still to today, right? The NAACP is still litigating cases around education in Detroit, across the country, around this question of what does it mean to provide like an equal education to students. So, I mean, what you have is a number of big cases that then lead up to what is going to be kind of the biggest crack in the wall of Jim Crow, which is going to be the Brown v. Board of Education Supreme Court decision. They don't just stop there per se. It's not like, oh, you know what? We got education, we're done, right? That's not the case. So they continue on in terms of in the 50s and 60s on a number of different cases around education, around voting, around death penalty, around housing segregation as well. Because one of the things I always explain to my students, which I know everybody on this panel already knows, and likely most people who are listening in to us today, it's not that like in terms of Brown v. Board happens and these schools in the South were like, yeah, that's what we really want to do. We really want to desegregate, right? Like even in terms of the 60s, right? Like these schools, right? Rice is moving at a glacial pace, right? Like it may have sped up a little bit in 2020, but those numbers in terms of entrance of Black students are not what they should be. Let's be very clear, right? So like in terms of what the NAACP is doing in terms of litigation around education, higher ed, and like and graduate education as well, is in terms of helping to apply pressure to schools who like only want to provide some type of kind of like token entrance to students, right? And so what actually does the court's command of desegregating education actually look like? And if it's not the court's command for public schools, for private schools such as Rice University, what does that look like to, as we've heard from Stephen and Micah, what does it look like to actually to not be critiqued by the media and or from other people on the outside? So the NAACP is operating kind of trying to push on the promise of Brown and trying to do much more in the 60s and 70s around the fight and the battle, which is an ongoing battle around education.
And, you know, Megan, you raise a lot of really important issues and, you know, external factors that were certainly going to be at Rice's doorstep soon enough. And, you know, that actually sort of reminds me or highlights a comment that we got from one of our audience members, which was, in addition to all the factors that we've discussed already, you also had a lot of business folks in Houston who also realized that it was time for, you know, the city as a whole to desegregate, which of course would include its colleges and universities, and that there may have also been additional influence and pressure from them as well. So, you know, one time we had a similar discussion about this at the university, and you know, someone admonished us that when we look back at these cases and these situations, we can't necessarily impose on those actors the same standards and customs and even values and morals that we carry today. It's really hard to do that. But, you know, quite frankly, there probably weren't, you know, a whole lot of folks in Texas or the South who were desegregating purely based on the moral issue, right? So it took that moral compass for many people to advocate, but it also took these other external factors pushing the issue so that folks would eventually do the right thing. So we are heading to the very end of our panel here. I want to do a little bit of rapid fire from our Q&A, and then I'll allow you all to give any kind of closing thoughts that you might have. It looks like we have 2 questions that are related to the law. So I see we have lawyers out there. We always have to ask the legal questions. 2 questions here, and whoever on the panel feels comfortable, just wanted to get clarification about what was the actual basis of the alumni intervention, under what grounds. My understanding from all that I've heard from you all today is essentially that they were saying the trustees did not have the authority to essentially not do what the charter said they had to only be for white students, but I'll allow one of you all to comment on that. And that also leads to the other question, which is, would Raymond Johnson have had any standing on the basis of his reliance on that offer for him to come to Rice? Would he have had any standing there to also intervene or participate in the lawsuit? So those 2 quick questions.
He might very well have, and it would have changed the contours. It's called detrimental reliance. They must have had a discussion with him, assuming it would go straight forward, and then it didn't. So they have this kind of fallback position and create a position for him. It just goes to show why the Jackie Robinsons of this world always had to be better than everybody else. He was chosen not only for his talent, but for his temperament. And I think he understood that the game was worth the candle for him. As to the first question about the alums, they had no business being in this thing. It is anomalous to me. And I tried to talk with someone who had clerked for this particular judge, and he said, it was a different time. And I think the judge probably did it to be sociable. That is, because the whole thing was being set up as a straightforward sort of, they're going to get the discretion that they need. I think that they said, well, it can't hurt, even though they technically had no legal standing in it. It just has always been a puzzle to me. And if I were teaching civil procedure, I would show how this is a good example where if you don't have a dog in the fight, you can't bring a case. I couldn't bring a case against Rice. I got no dog in the fight. They had a dog years ago when they attended, but alums don't have legal standing. It doesn't, otherwise they could contest every decision that's ever made. It's an excellent question. I've never been able to resolve it. And Stephen and I probably know more about this case than almost anybody else alive. And I've just never, it's not in the written record, let me just say.
Yeah, I will just add that one of the arguments that the alums were making was also that the reason they had standing is that they had given time and support, including monetary support, over the years to Rice, and that's what gave them a little piece of this pie.
Yeah, that's what's called a bribe. That's not standing.
Wouldn't have any standing here. And also like to address one of the questions that we've seen that Akilah, you got to a little while ago, is that how this is in the context also of what's going on around Houston in particular, that with the businesses and stuff like that. One of our commenters suggested, and I think correctly, that right around the same time, you've got a very tight-knit business community in Houston, fairly small. Houston is not the metropolis it is today. It was big, but it wasn't that big. And the business community was very much the central business district, couple of banks, couple of hotels, couple of department stores, and those were the people who ran those, and of course the media, TV and the newspapers. And when they got together and talked about what was good for Houston, there's sort of this ongoing story that's been revealed over the last couple of years, that they decided, again, it would look bad for Houston and be bad for Houston's future if they didn't manage the desegregation issue better than places like Little Rock was, and other places around the country, or even other places in Texas with school desegregation. And so there was this element of if we can make this happen quietly, then we can get past what would be the bad publicity. And in fact, they sort of did. There was sort of famously a news blackout over the course of a weekend when suddenly some of the counters in the cafeterias in the downtown area and things, and the diners opened their doors to a small number of African Americans. And suddenly Monday morning came around, they went, see, we did it. Everybody go back to work, go back to business. And that was around the same time too, that the trustees were making these discussions. So I think that there's definitely evidence that this is just what's going on at the movers and shaker level in Houston at that point. Is we got to get past this somehow. If we look like we're fighting it too much, it's just bad for the reputation. Again, not the right answer, not the right reason, but the results, I think, is something that we can at least take some satisfaction in.
That's an excellent point, and thank you to our audience member who raised that question and that issue. We could have a whole nother panel about how desegregation happened in Houston. It was a very unique circumstance. So I definitely want to be respectful of everyone's time, including our attendees and panelists. If you will give us just a few minutes to wrap up here. Again, I just want to thank each and every one of our participants here today, Dr. Wilson, Dr. Olivas, and Dr. Francis, for your wonderful insight into this issue. I can tell the audience, stay tuned. The task force is going to continue discussing these issues, and perhaps some of the questions that were raised today will be discussed sooner than you think. So just keep an eye out for that with additional programming from the task force. Again, don't forget to go to the website. There's just so much wonderful information, not only about programming, but all of the archives, all of the historical information that is such a huge part of the task force's work right now. And as we discover it, it is being posted for you to view. So if you haven't been there to see what our amazing historians, researchers, and student researchers have found thus far, please go there. I will give our panelists 1 minute, one real minute, that's 60 seconds down that minute. I'm gonna give each of you a minute to just give us any closing thoughts that you want to provide to our audience today.
That was aimed at me.
Go ahead.
One thing I had not thought of was just how transformative this president was. It shows the value of a president and a leader who makes his job contingent upon doing this and then does it, because it would have set the university back 20 years had he not done that at the time. And it would have gotten more embarrassing because the late 60s were when students were really active and the university would have been terribly embarrassed. So I think that I didn't know he'd come from Berkeley. I'd always assumed it was a bunch of private presidents, who'd come from private institutions. But I can't help but think it's because of Berkeley's reputation and his own acumen that he did the right thing. The fact that it fell apart was probably because he didn't have his lawyers to let it get out of control. I can't help but think that. But sometimes the right things happen, even if they fell apart early on. So I think that the narrative here actually is a very fortunate and positive one that people should be proud of, even if it were undertaken for the wrong reason. Sometimes great things occur for all the wrong reasons.
And I'll just say that although I made the argument that this is not an issue of the morality of it, I will say I don't think it was for the wrong reasons. Those were they undertook this for a lot of very sound, good reasons. They just weren't some of the reasons that we would like to have heard along at the same time, or even earlier. That when they finally made this step, they were good. They were good, sound steps for the aspirations that Rice had, and they were, at least we can give them some credit for recognizing that this was blocking Rice's aspirations. So you said earlier, maybe we don't want to project back onto the past sort of understanding the future. That's one area where I think that maybe that's where I can give them a little bit of credit and less blame for not being, as Michael has said, more woke than they need to be. So, I mean, I'll leave it at that. Thank you very much.
I didn't expect to hear woke 5 times on this webinar, but thank you, gentlemen. I'll use my minute to say and to advocate for. This is a panel on the legal battle over desegregating Rice, and it seems to me in 2020 coming out of historic protests in this country this spring and summer after Breonna Taylor and George Floyd, that it is really important to think about, like, perhaps in the 60s and the 70s, this is battle about desegregating Rice, but what does racial justice actually mean at a place like Rice University? And what is the role of the institution to make the place a more welcoming place for students as well as for Black faculty? And so that's something in terms of, like, as I think about the legacy of what it meant in terms of the legal battle to desegregate Rice University, I hope that means something bigger today in terms of a vision around racial justice. So I'll just leave it there. And I do think that this task force is a really, really important step in that. But I am, as an alumni, really interested in what actions the university is going to take after the task force and onwards into the future.
Thank you all again. Thank you for attending. Give us a few weeks and you should see this recording on the task force website along with the vast majority of all the other events we've had. So thank you so much. Enjoy your evening, and hopefully we gave you a break from the election. So that's something.
Thanks, Akila. Thanks, audience.
It's been a pleasure. Thank you very much.